Now comes section 99. We had made a reference to this section earlier when we started with the right of private defense. Section 97 opens with this declaration that the right of private defense is subject to the restrictions of section 99. So here we are, section 99, and we will now see what are the restrictions to the right of private defense which is granted by section 97 as well as 98. This is the first restriction. There is no right of private defense against an act done by a public servant, even though the act may not be strictly justifiable by law, provided that the act is done in good faith, that is with due care and attention, and under color of his office. This right will, however, still be available. The right of private defense will still be available even against an act done by a public servant if the act causes apprehension of death or grievous hurt. A person is not deprived of his right of private defense against an act done by a public servant unless he knows or has reason to believe that the person doing the act is such public servant. So for the first restriction to apply, it is necessary that the person should know or should have reason to believe that the person doing the act against him is a public servant. Here is the second restriction. There is no right of private defense against an act which is done by the direction of a public servant. In the first restriction, the act was done by the public servant himself. In this second restriction, the act is done by somebody else but under the direction of a public servant. And the right of private defense will not be available even if the direction is not strictly justifiable by law, provided the direction is issued by the public servant acting in good faith under color of his office. However, the right of private defense will still be available if the act causes apprehension of death or grievous hurt. Any act which causes apprehension of death or grievous hurt is out of this restriction, and therefore we can conclude that an act which causes apprehension of death or grievous hurt, the right of private defense will be available against such act even if it is done by a public servant, even if it is done by the direction of a public servant. For this restriction to apply, it is necessary that the person knows that he is acting by the direction of a public servant, and that person should state his authority, or that person should produce his authority if demanded, if he has the authority in writing. This is the third restriction. There is no right of private defense where there is time to have recourse to protection of public authorities. So, in every case where there is time to take assistance of a public authority, the right of private defense cannot be exercised. In other words, the right of private defense under section 97, 98 is available, can be exercised only if assistance of public authorities is not available in time. And this is the fourth and the last restriction. The right of private defense cannot be used to inflict more harm than is necessary for the purpose of defense. In other words, under the right of private defense, the defender cannot inflict more harm on the attacker than is necessary for the purpose of defense. It has already been emphasized that this right is a right for protection, is a right of defense. It is a preventive right. It is not a punitive right. In exercise of this right, only that much harm can be inflicted on the attacker which is necessary for the purpose of defense. No more. What is the extent of this right of private defense? What harm can be caused by the defender to the attacker? Section 100 IPC declares that in exercise of the right of private defense of body, the defender can cause any harm to the assailant, including voluntarily causing his death. Under Section 100, the right of private defense of body extends to voluntarily causing death of the assailant, but the right of private defense of body extends to this extent only in case of 7 specified circumstances. We will now see what are these 7 specified circumstances. First, where the right of private defense is exercised against an assault causing reasonable apprehension in the mind of the defender that death will otherwise be the consequence of such assault. We are concerned here with reasonable apprehension in the mind of the body, in the mind of the defender. It is immaterial whether, as a matter of fact, this assault would have caused the death or not. What matters is what apprehension is there in the mind of the defender. Second, this right of private defense causing death of the assailant is available against an assault causing reasonable apprehension that grievous hurt will otherwise be the consequence of such assault. Third, the right of private defense of body will extend to the extent of killing the attacker against an assault with the intention of committing rape. Fourth, against an assault with intention of gratifying unnatural lust. Fifth, against an assault with intention of kidnapping or abducting. Sixth, against an assault with intention of wrongfully confining a person, causing reasonable apprehension that he will be unable to have recourse to public authorities for his release. And lastly, seventh, against an act of throwing or administering acid or attempt to throw or administer acid with reasonable apprehension that grievous hurt will otherwise be the consequence. These are the 7 circumstances in which, in exercise of the right of private defense, any amount of harm can be caused to the assailant, including causing his death. Section 100 IPC is applicable only in the 7 specified circumstances. Wherever Section 100 is not applicable, the right of private defense of body extends to voluntary causing to the assailant any harm other than death. It does not extend to voluntary causing of death, but it extends to causing of any other harm. Section 100 is that rare section, that rare provision where a private individual is given a right to cause death of another person. Of course, the circumstances are specified there. The assaults and acts against which that right is given are also specified. The apprehensions which are to be caused by the assaults or acts are also specified in section 100. And further, section 100 is subject to the restrictions imposed by section 99. But with all these restrictions and specified circumstances, one is still amazed that the law gives a right to every private individual to kill another person. In section 101, however, the right is only to cause any harm other than death. When those 7 circumstances are not there, then the right is limited to causing any other harm except